This is the FM Gold channel of All India Radio. In the program News Analysis Now, we bring you a discussion on disqualification of members of parliament after conviction in criminal cases. The participants are Vinod Sharma, political editor, The Hindustan Times, and Manikant Thakur, AIR correspondent.
Mr. Vinod Sharma, welcome to the program. With a very dramatic turn of events, which began, in fact, yesterday with the disqualification of the first ever member of parliament, Mr. Rashid Masood from Rajya Sabha, the RJD chief Lalu Prasad and JDU leader Jagdish Sharma today were also disqualified as Lok Sabha members following their conviction in the fodder scam. While Mr. Lalu Prasad stands disqualified for a period of 11 years, that's for 5 years for jail term and 6 years subsequent to his release, Sharma stands disqualified for 10 years, 4 years in jail and 6 more years after that as per electoral laws, which is effective in the case of Mr. Rashid Masood also. Given the fact that at a point of time it was said that there was consensus amongst the political parties to bringing in a legislation against this, it was negated and the Supreme Court's wishes were upheld for the larger interest of the people. How do you look at the political situation, or rather a fallout?
Well, I think that first of all, no political party, whether in power or out of power, can seem to be acting at cross purposes vis-a-vis a Supreme Court order or a judgment. And this July 10 order of the Supreme Court was very clear that Section 8(4) of the RP Act, which gave 3-month cushion period to convicted members of parliament and state legislatures to go and appeal to higher courts to seek a stay on the conviction stroke sentencing, was ultra vires of the Constitution. Now the court said that it was not in consonance. This two sets of law. There is one set of law which disqualifies a person from contesting an election if he is convicted in a criminal case. And there is another set of law as delineated under Section 8(4) of the RP Act, which says that a person who is disqualified while a court judgment can continue as member of parliament while his appeal is being heard by a higher court. And the time period for going into appeal is 3 months, which is about 90 days. Now, this judgment of the Supreme Court was seen with a degree of trepidation by the political parties, especially because we are today in an era of coalition where governments are running the affairs of the country on wafer-thin majorities in parliament for many years now. We haven't seen a single-party government in this country since 1989. And given the ground realities, it was felt that this Supreme Court order required to be negated wider legislation by Parliament. And there was a broad agreement in an all-party meeting. But then, as things moved, there was a clear and present outrage that was felt by political parties from amongst the people. They thought that it was a provision primarily aimed at protecting criminals who have managed to enter Parliament. And now, the fact is that about 30% of the members of Parliament and state legislatures have cases against them. This doesn't necessarily mean that they are criminals, but in public life you have cases registered against you at times by your political rivals on the basis of exaggerated allegations and claims, and at times even, unfortunately, evidence is manipulated to frame you under the law. So there was some degree of conviction on the political parties that this order of the Supreme Court could disturb the very tenuous, very jerry-built coalition arrangements that have happened in this country for the past couple of decades. But finally, as we all know, an intervention by Rahul Gandhi, who found that during his travels across India that people were grossly unhappy with this legislation. And in the meanwhile, the principal opposition, perhaps on the basis of similar inputs, had also started prevaricating whether or not it wanted this law to be amended, or this law to be amended in order to negate the court judgment. But what actually triggered the controversy was the bid to promulgate an ordinance in between two sessions of Parliament. Now, promulgation of ordinances between two sessions of Parliament is a commonplace thing. It has happened many times.
But it was really not necessary.
But here was a situation. And ordinances, as per under the Constitution, you can bring an ordinance because if there is an urgent need in public interest. Now, where is the public interest here? And where is the urgent need? These were the questions that were asked. So we saw the ordinance being abandoned by the government, and also the proposal to amend the law because the bill which seeks to amend the law is currently pending before the House and is the property of the House, it can only be withdrawn with the consent of the House, which might happen in the winter session. But the short point in the story is that today, if a member of parliament or if a member of the state legislature is convicted for a criminal act, he stands disqualified immediately.
Just coming back to the point you made about Mr. Rahul Gandhi, before that, President Pranab Mukherjee had also questioned the government's decision on the ordinance, as you were just saying, that what was the hurry, what was the need. Then why at a point of time when the principal opposition party said, yes, I am in it, I am with you, and suddenly withdrew from the decision?
2 points, first of all. The President has never made known his mind on the issue. It's a fact that he called the concerned ministers for consultation before signing the ordinance. Our President, Mr. Pranab Mukherjee, runs a very constitutional presidency. He is perhaps very well aware that he can at best advise off the record and without the public getting to know the government. But he also knows that if he sends the ordinance back without signing on the first occasion, if it is reverted back to him by the Council of Ministers, he has to go by the advice of the Council of Ministers. What I am saying is the President knows his limitations under the Constitution, but at the same time, we fortunately have today a President who has a very good knowledge of the Constitution and the functioning of the government, and perhaps also the implications of a legislation which is kind of a bit insulated from public sentiment that whether or not to have it. But he never made his comments or never made his opinion known at all in public. If at all, he shared it with the ministers whom he called, but he never made it public. At the same time, I think that this ordinance, the way Mr. Rahul Gandhi reacted to the ordinance, one can go on disputing the way he did it, but then it's essentially a means to the objective situation. And the objective was noble. The objective was to cleanse the political system. And I think that insofar as the objective is attained, we can forget the way he expressed his anguish. And I think in this case, Mr. Rahul Gandhi's intervention would be remembered for blocking an ordinance which was not in sync with the overall stated objective of all political parties to contest corruption in public life.
But then the other part of criticism which says that he did it just to favor a particular party so that in the state assembly elections or the forthcoming general elections, he could be benefited from it.
This is something which is an interpretation which is being induced to his action. And it may be the right interpretation. But then what's wrong in being sensitive to popular opinion and popular sentiment? Governments are expected to be decisive and sensitive. And I think that in this case, there was a decisive intervention, which was at the same time a sensitive intervention. And I indeed also wish that perhaps he could have said it more softly. But then I always give our young leaders some benefit of doubt, regardless of which party to which they belong. Because if we are insensitive and we are not fair to our young leaders, we will be denying this country a second line of leadership it needs at this juncture. It needs direly at this juncture.
Mr. Vinod Sharma, you have been watching the coalition politics for the last 2 decades very keenly, and you have been commenting on that. How do you look at the situation now that the state assembly elections are there and then the general election is just coming forth, and the coalition politics has to be there in the state and in the center?
Well, you see, state governments and certain state governments have been very lucky that they have full majority in the state legislatures. And on the strength of that full majority, they have been able to register a performance which is praiseworthy. There are many states which have done this. But at the same time, the comparison made with the central government is perhaps a little unfair because we haven't seen a single party government or a complete majority government in our parliament at the center, as I said earlier, since 1989. And then there are factors built into coalition politics which are deliberating, which at times make governance very difficult. For instance, the first casualty of coalition politics at the center has been the Prime Minister's prerogative to constitute his Council of Ministers. And a Prime Minister who hasn't had a full say in the constitution of his Council of Ministers is at the end of the day, if not accountable, he is responsible for their actions. Because the buck stops at his table. He is the first amongst the equals, despite his diminished stature on account of the numbers in Parliament. So, I think that whoever forms the next government in these 5 states and consequent to this in the 2014 elections, that person will have to be sensitive and will have to be accommodating towards the demands and the desires of the constituent parties that form the combine. And unfortunately, many a times, the demands of constituent parties are whimsical. They also, without suggesting that the national parties don't have to answer questions on issues of lack of transparency, on issues of lack of probity, without for a moment letting them off, may I also ask that our political parties of national stature, are they dealing, do or do they not deal their alliance partners with kid gloves, regardless of which national party is in power? And each one of them has done it. We have seen it since 1989. Each one of them has treated the regional parties with kid gloves. And regional parties, for their part, have, in my very humble view, have been a trifle short on sagacity and trifle high on being whimsical and at times arrogant.
Earlier we used to talk and discuss about the politicians and criminal nexus. Now we see politicians turning criminals or criminals turning into a politician. Given the fact that in Rashid Masood's case, we have some component from media which was also the part of the corruption. You see, there's the name of the editor of a daily in Uttar Pradesh. He had met Mr. Rashid Masood to arrange a medical seat for his son. How do you look at this situation?
Well, you see, that's what I said, that in our democracy, there are four pillars: the legislature, the judiciary and the executive. And the fourth pillar is the media, fourth estate. Over a period of time, all these three other pillars are being sought to be made accountable for their actions. And there are laws to do that. There are procedures to do that. Even the judiciary, we have seen impeachment proceedings against a Supreme Court judge recently. Leave that aside. What I am saying is that the media, as Vice President Hamid Ansari said at a seminar a couple of years ago, that of the four pillars of democracy, the only self-declared profiteering pillar is the fourth estate. And because it is a profiteering pillar, its responsibility to be fair in terms of dissemination of information and to be fair in its conduct and to be above reproach is greater. And I think at some stage, the Indian media will have to introspect. It is already introspecting, but it's generally felt that there is no consensus as to how to deal with the black sheep in our profession. There are black sheep in every profession, and the media is no exception to the rule. But while there are black sheep in the media, there are also some very honest journalists this country has produced, like some very honest judges, like some very honest legislators, and like some very honest bureaucrats. This country has produced some very towering and very honest journalists who suffered for having the courage to stand up in a minority of one and be counted on certain issues. So we have to maintain a robust and an independent press. But then at the same time, besides being robust and besides being independent and irreverent to authority, the Indian media has to be transparent and speckless clean. Now that's easier said than done, but efforts need to be made. There should be strong internal mechanisms, if not collectively, at least at the level of individual newspapers. Say for instance, the Hindu newspaper has its own internal ombudsman. It also has the People's Editor, who keeps on giving feedback from the people to the higher editorial management in order to achieve perfection. I think it's a good example which other newspapers can follow.
Mr. Vinod Sharma, thank you very much for talking to All India Radio.
You were listening to a discussion on disqualification of members of parliament after conviction in criminal cases. The participants were Vinod Sharma, political editor The Hindustan Times, and Manikant Thakur, AIR correspondent. It came to you in the program News Analysis, produced and presented by the News Services Division of All India Radio. This program is also available on our website newsonair.nic.in. You may email your opinion about this program at airnsdtalks@gmail.com.